Welcome everyone to our webinar on effective strategies for managing non-compliant franchisees. My name is Olivia Locascio. I'm a lawyer in the franchising team here at LegalVision. My co-host is Cameron Graf, who's a senior lawyer in the franchising team at LegalVision. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email. Be sure to submit your questions in the chat box and we'll answer them at the end. And please complete the feedback survey after the webinar. So today we will be discussing strategies to manage non-compliance in your franchise network, including how to prevent it from happening in the first place. And now Cameron will speak about the importance of compliance and communicating expectations.
Thank you, Olivia, and thank you everyone for joining us today. So before we jump into strategies for managing non-compliance, I thought it would be useful to talk about why franchisors should care about compliance in their networks and talk about what compliance actually means. So to a franchisor, it means that all your franchisees and your staff generally are following the obligations set out in the franchise agreement, any related documents, and as set out in the franchising code of conduct. On a very tangible level, it means that all your franchisees are providing services and selling your products in accordance with the rules, procedures, and processes that you have set out for them, potentially in your operations manual or in other training and guidance. It's also important that all your franchisees are making sales and interacting with customers according to any rules that apply to your industry. Some of you may be in regulated industries as well, and every consumer law will apply in most of these transactions as well. And then finally, when we talk about compliance, we also talk about adherence to the cultural values and expectations of a franchisee in the network. There might be a particular way that you want your brand to be represented and how you want interactions to occur in a professional or friendly manner. And these all come into being when we say, what is compliance? And the question of why we want compliance for our franchise networks, obviously the potential improvements in business performance and better experience for customers and increased satisfaction, and then in turn drive more referrals of customers, increase sales and whatnot. And from the franchisor's perspective, having compliance across the network makes it easier to manage the franchisees. You can more effectively put your attention to business growth plans or addressing any potential challenges that may face the network. So overall, compliance is a good thing. You don't want to have a stigma of this word because of how much it can help the network. Now, when we talk about establishing the expectations of compliance, it's important to see how you communicate your expectations to franchisees. So I'm not going to talk about how you can establish this culture of compliance and how to sort of set yourself up for success. And this is relevant for any new franchisors that are joining us or any existing franchisors who have grown in recent years. So some common sense things to keep in mind: open and clear communication. Now this should start early on in the piece when you are recruiting franchisees to make sure that everything that you or your sales team or staff are telling to franchisees matches what they're going to be given or experience in the franchise network. So this means that ensuring your sales pitches and verbal promises align with all written documents, something that as lawyers we often have to contend with, and any induction and training processes clearly outline what are the expectations of a franchisee in the network. This is going to set them up for success because in essence they know what they're getting into, and you're going to avoid any misleading or confusing scenarios. Part of outlining expectations and the standards that you expect of franchisees does sometimes mean either having minimum performance criteria or growth goals and milestones that you actually provide to franchisees either in the franchise agreement or as separate documents early on. This might be during the training process, during the induction or sales pitches, or once they've within their first few months. You ideally want to give them as much notice of what you expect from them, because this is going to tie into what is compliance. If you want them to reach certain standards and have certain goals to get to, it's important to clearly outline what those are. On the topic of setting performance criteria, you want to make sure that you aren't actually changing these too often. Because they can be so essential to complying with the agreement, they can be considered part of the legal terms, either directly or via extension. So if you change these without proper consultation or agreement, you could be considered to be changing the goalposts, and it may actually reduce the enforceability of those performance criteria, which makes it harder to get franchisees to be compliant because it will be unfair. Once you have these criteria or standards that you've set out and you've put them in writing, it's also important to make sure you've fostered a culture of performance. And this goes to how you talk to franchisees about their conduct in a positive and aspirational way. This can be talking about the network performance overall, looking at customer satisfaction through online reviews, referrals, word of mouth, or maybe even goals that you're trying to set for specific sections of the business or the network to try and improve how they're operating. And this can be a collaborative process as well when you talk about setting goals. Then finally, as part of this performance culture, you want to make sure that your franchise agreements are clear on the expectations and obligations on franchisees. Any ambiguity in the terms or their rights can lead to confusion and can inadvertently lead to non-compliance, not because of any malicious intent, but just because it wasn't clear what the expectations were. So you want to make sure that your franchise agreements and any supporting documentation are comprehensive and not contradictory to each other, and you have that legal review done. Olivia is going to talk a little bit more about how you actually get franchisees to start on their journey to being compliant through training and support.
Thank you, Cameron. Ensure that your training program covers not only the operational aspects, but also emphasizes the importance of compliance with standards, policies, and procedures. Offer regular refresher courses and workshops to reinforce these concepts. Additionally, establish a support system where franchisees can reach out for guidance or clarification whenever they encounter difficulties in compliance. The operations manual should serve as a comprehensive guidebook for franchisees detailing all our operational standards and procedures in a clear and accessible manner. In addition to this manual, consider developing supplementary resources such as instructional videos, online modules, or FAQs to address common compliance issues. Make sure these resources are readily available to franchisees through an easily accessible platform such as an online portal. Actively engage with your franchise network and establish open channels of communication for feedback. Conduct regular check-ins with franchisees and host group discussions. Consider forming a franchise advisory council comprising representatives from different and various franchise locations. This council can serve as a forum for franchisees to voice concerns, share best practices, and provide feedback on the effectiveness of existing systems. You'll be able to use this feedback to identify areas for improvement and implement necessary changes to enhance compliance across the franchise network. And now over to Cameron to discuss incentives for compliance.
Thank you, Olivia. So, two main strategies for increasing compliance can be broken down to encouraging it positively, using incentives, which I'll talk about now, and later on we'll come back and talk about the consequences of non-compliance. Effectively, a carrot and stick approach. So when we talk about incentives for compliance, how can you encourage franchisees to want to do the right thing? You can very simply offer rewards or meaningful incentives to them, to franchisees who consistently meet or exceed the standards. Effectively, they're doing a good job and you reward them for it. Now, this obviously will help motivate franchisees to want to do better if the rewards have substance and are important enough to them, either in a financial manner or even at a personal, emotional level. Some things that franchisors can do to reward good performance can be recognizing them in meetings or in conferences, or sending out newsletters with a monthly spotlight on particular franchisees who have done well, doing social media posts which outline particular franchisees that you're proud of, or it may be a particular review you've gotten from a customer or a franchisee, and you want to call this out. And this ties back to establishing that culture of performance because you are recognizing it in a meaningful but, let's say, intangible way. Now, more tangible rewards could be financial. This could be giving them gift vouchers or giving them gifts or presents, taking them out for a dinner or a lunch or some kind of positive experience that has a financial component to it. Or if you really want to show franchisees that you encourage compliance, you can give them a discount or rebate on the royalty fees or licensing fees that they may pay to you as a franchisor. And we have seen some franchise networks that have a compliance discount to the royalty fee for staying compliant with the franchise agreement and not being in breach of the franchise agreement. One thing that is important to consider is you want to make sure that your incentives for compliance are not actually punishments for non-compliance, because the consumer law has said that when you punish someone for breaching a contract, it could be considered a penalty under the consumer law. And not only is that unenforceable, but as of November last year, you can now be fined if you try and exercise those rights. So it's always important to think about not just how it's written on the paper, but how it works in practice and how your team may be addressing compliance and incentives for compliance within the network. Now, if you do have non-compliance in the network for particular franchisees, Olivia is going to talk through how you can address that.
Thank you, Cameron. Establish a formal process for implementing performance improvement plans for franchisees who are not meeting compliance standards. This process should be clearly outlined in the franchise agreement or operations manual to ensure consistency and fairness. The performance improvement plan should be a collaborative effort between the franchisor and the franchisee, with both parties actively involved in identifying areas of improvement and developing strategies to address them. In the performance improvement plan, clearly define the specific areas of improvement that the franchisee needs to address. These areas may include operational standards, customer service, financial performance, or any other relevant metrics. Set realistic timelines for achieving these goals, taking into account the complexity of the issues and the resources available to the franchisee. Ensure this is documented so you can show attempts to help the franchisee improve and address the issues in case you later need to issue a breach notice. Additionally, establish clear benchmarks for success to measure progress and determine whether the franchisee is meeting the expectations outlined in the performance improvement plan. Schedule regular progress reviews to track the franchisee's performance against the goals outlined in the performance improvement plan. These reviews provide an opportunity to assess whether the franchisee is making sufficient progress and to identify any obstacles or challenges that may be hindering their success. During these reviews, provide constructive feedback and guidance to help the franchisee stay on track and address any areas of concern. Be supportive and encouraging, but also hold the franchisee accountable for meeting the expectations outlined in the performance improvement plan. Now over to Cameron to discuss regular monitoring and reporting.
Thank you, Olivia. One of my favorite topics. So now that you have set up this culture for franchise compliance, you've got your documents in order, and you've looked at both how to incentivize compliance for franchisees and potentially help those who are struggling. The next question is, how do you make sure that you are actually improving compliance over the short or long term? And we always recommend implementing a degree of systems for monitoring performance and compliance that are appropriate to the size and nature of your franchise network. Some examples that you may want to do with the network is conducting periodic audits or inspections, however formal or informal you want them to be, to see how a franchisee is performing their business compared to those standards and expectations that you set for them. You can also run reports on business data that you have collected in the CRM system, customer relationship management, or conduct assessments of how the business premises is looking, how the website is doing, how the social media is being managed by the franchisees. All these sorts of things you can look at from a franchisor's perspective. And you can decide how high level or deep to go into. Some franchisors have the rights to inspect business records and then reserve rights to have an external auditor come and do further investigations if there is potential non-compliance that may be suspected. And this can actually be very important as a franchisor when we're talking about compliance with employee obligations and tax reporting. to avoid any potential liability for the franchisor. Now, when you're doing this monitoring and reporting, it's important to actually give the results of your investigations to a franchisee in a way that will help them improve their compliance. So if you conduct an audit, we recommend the franchisors give some sort of mark or grading on how the franchisee has done in that particular assessment so they can see how they're tracking and then can implement any recommendations. So whether it is quantitative feedback that you've collected from the business data or even qualitative feedback from your own inspections or mystery shopper reviews or online reviews, it's important to explain what the franchisor's assessment of the franchisee's compliance is and say to them not only if they have passed or failed a particular assessment, but what they've done well at and what they haven't done well at, so that you can say to them, here's how I want you to improve so you can be compliant and you can meet the expectations we've set for you. Now, the other things that you can use from a qualitative perspective, but can be risky, is looking at your interactions with the franchisees. Has there been a change in the attitude of the franchise in meetings or discussions with you? Have they reduced their attendance at meetings or conferences, or are they taking part in a different way? Has their responsiveness reduced? These are sorts of things that you can also look at in conjunction with the business data to try and work out what's going on with the franchisee. And finally, as Olivia mentioned, if you do discover that there are areas a franchisee can improve upon, whether they're on a performance improvement plan or just generally being managed, make sure you document not only the areas you want to improve, but what you want to see them implement in their business to improve for record keeping and also to help the franchisee be compliant. Now, Olivia is going to talk about what happens if, after all that, you're faced with a situation where a franchisee still isn't quite getting to where you want them to be in terms of compliance.
Thank you, Cameron. Franchise agreements serve as the legal framework governing the relationship between franchisor and franchisee. It's crucial to enforce these agreements rigorously to maintain the integrity of the franchise system and protect the interest of all parties involved. Clearly outline the consequences of non-compliance within the agreement, including specific actions such as warnings, fines, suspension, termination of the franchise agreement, or legal action if necessary. By clearly communicating these consequences up front, franchisors set clear expectations and establish accountability within the franchise network. Issuing a breach notice should be a strategic decision made with careful consideration of the circumstances and potential consequences. On the one hand, over-issuing breach notices without taking appropriate action can diminish the credibility and effectiveness of the enforcement process. Franchisees may become desensitized to the threat of consequences if breach notices are issued too frequently without follow-through. On the other hand, under-issuing breach notices may signal leniency and lead to franchisees not taking compliance issues seriously enough. It's essential to strike a balance and issue breach notices judiciously, reserving them for significant or recurring instances of non-compliance. When deciding whether to issue a breach notice, consider how much time has passed since the default event occurred. The timing is relevant because it can impact the perceived seriousness of the violation and the urgency of the response. Issuing a breach notice promptly after the default event demonstrates a proactive approach to enforcing compliance standards and sends a clear message that non-compliance will not be tolerated. However, if too much time elapses before issuing the notice, it may appear that the franchisor is inconsistent or lax in enforcing the agreement. Additionally, some franchise agreements may specify a time frame within which breach notices must be issued, further emphasizing the importance of timely action. And remember, the Franchising Code of Conduct requires a reasonable period that doesn't exceed 30 days, but you can give more or less time depending on the circumstances. Ensure the remedies in the breach notice align with those that are in the franchise agreement and any operations manual. And now over to Cameron to discuss mediation and conflict resolution.
Thank you, Olivia. So when we're talking about compliance, it's not always so straightforward. You may have a situation where you have issued a breach notice and Then you have a franchisee who responds formally or informally, outlining a dispute to that breach. This could be a situation where they allege that the operations manual or franchise agreement wasn't clear and it contained some ambiguities, and this has led to the non-compliance that's been alleged, but you now have a dispute on your hand. The Franchising Code of Conduct encourages all participants in the franchising industry to try and resolve these disputes internally through the dispute resolution process, whether this is informal meetings, negotiations, or a more structured alternative dispute resolution method, such as mediation or conciliation, before going to legal action. Obviously, once parties get to court, it's very hard to preserve the relationship between a franchisor and franchisee that is irrevocably damaged, and also the time, costs, and resources that have been put into court proceedings is not beneficial generally, unless it's your last resort. So if as a franchisor, you're addressing non-compliance in the network and you're faced with a potential dispute, make sure that you seek advice on how much significance this dispute has. Is the franchise agreement contradictory, or has your enforcement in any way been contrary to what the agreement says or what the franchisee's rights under laws may be? Have the laws changed or updated? So the documents need to be amended to keep up with those new regulatory changes. And if you, pursue the dispute with the franchisee, are you going to open up potentially more issues about the network that you may not want to address at this time? These are all important questions, as Olivia mentioned, to exercise judiciously and with the strategic enforcement in mind to make sure you don't make a bad situation worse. What we often see in franchising disputes with the franchisor are counterclaims that arise as soon as a breach notice or a threat of termination has come up. And it's important to anticipate what kinds of complaints or counterclaims a franchisee may raise in order to defend their conduct, or at least try and level the playing field when talking about who was more in the wrong. Some of them do try and use this as leverage, even going so far as trying to get out of the franchise agreement entirely. So you want to be mindful of these sorts of issues cropping up unexpectedly. Now, if you do find that there is non-compliance across the whole network, or you have a situation where multiple franchisees raise the same issue or grievance, the Code of Conduct actually does provide for a group dispute resolution process where, despite confidentiality obligations, franchisees can resolve their disputes together if they have the same or similar issues. Now, as a franchisor, you are obligated to take part in this process, but you want to think strategically, what is the best way to resolve this particular issue or dispute? It may be the case that trying to resolve this non-compliance that you've seen across the network with all franchisees, and if they've raised this issue in dispute with you, addressing with them comprehensively. But there may be matters that are better dealt with on an individual basis between various franchisees, and this is something that should be talked about with the various franchisees to make sure that the dispute is being resolved as productively as possible. Over to you, Olivia, to round us out.
That concludes the main part of our webinar. You might find our franchisor handbook useful. You can download this by accessing the handout panel of this webinar or scanning the QR code on the screen. We also have an upcoming event that may be of interest to you on preventing sexual and gender-based harassment, your WHS legal duties. That will be held on Wednesday, the 24th of April, 11 a.m. and you can register at the link on the slide. We're going to answer your questions shortly. While you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all of your business's usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts. And for franchisors, that means their franchise agreement, the disclosure document, the key fact sheet, and the annual update to the disclosure document and all relevant ancillary documents. Unlimited legal advice consultations and unlimited domestic trademark registration and much more. We also offer a dedicated service for in-house teams and general counsel to manage your high volume business's usual legal tasks. To learn more about how membership can help you request a free consultation when the survey appears at the end of this webinar. And now we'll answer some of your questions.
Thank you very much, Olivia. So we've had a couple of questions submitted by participants, but please feel free to submit any more using the question function on the webinar. So the first question is, what is the franchisor's liability for non-compliance by a franchisee? So when we talk about the franchisor's liability, it's important to remember there's no default responsibility or liability that the franchisor has for its franchisees. The nature of the relationship between franchisor and franchisee is independent business operators. A franchisee does have to follow your rules and conform with the standards you've set out, but they are an independent business operator, their own ABN, own staff, and whatnot. However, there can be situations where a franchisor is responsible for misconduct by a franchisee. And the common situations that we see in recent years are for employment matters, potentially tax matters, particularly superannuation, where franchisors can actually be responsible for underpayment of entitlements that have occurred across the entire franchise network. 7-Eleven was a major case a number of years ago, and there have been a few more cases since then that talk about the concept of vicarious liability, which is now entrenched in employment law. The other potential liabilities franchisors should consider is being in a regulated industry. If you have set out particular standards or processes of how franchisees should deliver the services, and that is contrary to the regulations that franchisee has to follow, this could potentially create some liability either with a regulator of that industry or in a dispute with the franchisee. Effectively, you told them to do the wrong thing, and if they have been fined or breached an obligation to a customer, then this would come back to the franchisor. And this can also apply for consumer law when it comes to setting prices and dealing with competition law generally. So it's important to make sure that you stay up to date on laws that apply to your business and consumer law generally, and consider how any misconduct by franchisees could actually be linked back to the franchisor in any of those standards or procedures that you have set out. We have another question. It's quite a wordy question, so we may have to summarize it. In essence, the question is, as part of doing ongoing compliance and business health checks, how transparent should we be with franchisees? And the context for this question is that the person who asked it has a background in education and believes that sharing performance outcomes are beneficial, and is worried that not being transparent is counterintuitive. Now, I would agree with the comment here that lack of transparency can be detrimental and not in anyone's interests. Finding the balance between how much information you provide is key. Now, I would recommend erring on the side of more transparent. So, for example, if you are doing an assessment of social media or food health safety standards for a retail business, going through and setting out specific issues you found, and even using picture evidence can be a very effective way of not only keeping track of your own records as a franchisor, but also giving the franchisee very tangible items to address and fix up. And if you are giving them a score that shows them they pass or fail, give them the actual score. And some franchise networks have a very sophisticated system of assessing based on weighting factors and location, and these are generally more helpful because you can show that you're not being arbitrary in your decisions, but you are actually giving a consistent assessment for the franchisee based on previous years or quarters and with compared with other franchisees. And this is important as a franchisor because the obligation of good faith requires you to act with a certain degree of honesty, integrity, and transparency in terms of not being arbitrary in your decision-making process. So actually showing those results can be a way to make sure you are meeting this standard. All right, we've got another question that's just been submitted saying, can you apply a penalty to a franchisee who has poached business from another franchisee's exclusive territory? The short answer to this question is you can't apply a penalty necessarily because a penalty is not enforceable at law, but this could be a breach of the franchise agreement if they have gone outside their requirements. So if the franchise agreement says they have to operate within their allocated territory or marketing area and have done this without permission or consent and against other guidelines, then it could be a breach notice. And that breach could require them to cease communications with that particular customer, to hand over any particular client work or customer work to the more appropriate franchisee, or even to potentially share some of the revenue. But again, you want to be careful that you're not necessarily punishing them for the wrongdoing. You're trying to get them back into compliance and doing the right thing. And obviously, if they consistently fail to meet this obligation, then it's a question of termination. But as a franchisor, you also want to be mindful that you may not have necessarily suffered the loss. It may be a loss that another franchisee has suffered. And so if you try and penalize the franchisee who did the wrong thing by taking more money from them, by increasing their fees, if you're not actually passing this on to the franchisee who suffered, well, that can also be in breach of your obligations under consumer law because you are penalizing them and taking benefit for yourself, but you as a franchisor hasn't actually suffered the loss. And one more point on this issue, because I have seen this come up in various franchise networks, always important to consider what is going to be best for the network. Yes, there are obligations to specific franchisees and their rights and franchise agreements that should be protected, but trying to reach a compromise that works for the network and franchisees can be very helpful. And if customers have been poached, which does happen from time to time, but there is a reason why they want to work with a particular franchisee over another, you have to ask the tough question. If I, as a franchisor, force one franchisee to stop servicing that customer, will the network as a whole lose this particular customer? And effectively have a lose-lose situation. So trying to address these questions and situations when they arise, not just from a legal perspective, but also what I say, a commercial and relational perspective, can be very important to help you decide what you would like to do. Very good question. And then another question, I'm just how are we going for time? Oh, it's still got time. I have a franchisee who's breached the agreement, and I'm assuming they've issued a breach notice, but wants more time to fix it. However, I'm worried about being too lenient. What should I do? Well, Olivia, do you want to take this question given you spoke about breach notices and time for remedy?
Yes, I can. The question, if you could please repeat the question, that would be.
Sorry, the question is, I have a franchisee who has breached the franchise agreement and I've issued a breach notice, but wants more time to fix it. I'm worried about being too lenient. What should I do or how should I approach this?
Absolutely. Well, as mentioned before, the franchising code of conduct has a requirement for a reasonable period, which need not be more than 30 days. But you can take this requirement as required given the circumstance. I guess the factors that you'd have to consider would be how often this particular franchisee has breached before. If this is a first time breach, maybe it might not look too bad on you to be able to provide them more time. Depends on the facts of the actual breach itself as well and the circumstances that led to the franchisee to breach, which might be many of them out of their control. It depends on how well that they are achieving what they need to achieve under the franchise agreement outside of this particular breach. I'd say that, yeah, there are a few factors in mind when it comes to that, but it's definitely worth considering whether allowing for the extra time would mean that there's a risk of appearing too lenient. And franchisees do talk to each other. So if one franchisee potentially got a longer period of time than another, franchisors should keep in mind that that communication can be circulated amongst franchisees, and then there's the risk of a cranky franchisee that's not afforded the same opportunities as perhaps another one. So that's something to keep in mind as well.
Absolutely. Always a balance of that compassion versus setting a standard is a very important question that Olivia and I always talk to our clients about as part of the strategic enforcement of the agreements. I think we've got a follow-up question to the earlier one about poaching. Would we not be breaching my agreement of exclusivity by turning a blind eye to poaching? Again, thank you very much. A good question to ask. Now, as a franchisor, when we talk about strategic enforcement, one term or provision in the agreement that you may not have noticed at the end of the agreement is what we call the no waiver. And it's a very standard term in almost all franchise agreements, and a lot of lease documents and licenses have it as well. It effectively means that a failure to take any action or to exercise any of your rights in the agreement doesn't necessarily mean that you have waived your right to take action later on. And this is very important for franchisors when considering how, if, and when to take action. And using this particular topic, the poaching issue and breach of exclusivity, the first response may be issuing a warning letter, as Olivia talked about, or sitting down in a meeting with both franchisees and very clearly outlining that this was a breach of exclusivity if the agreement provides that, but talking about how this can be prevented in the future. Because maybe the solution here is not strict enforcement of the agreements, but maybe the franchisees would actually prefer to trade customers. And we've seen the situations where, despite territory requirements and maps that have been outlined, various franchisees say, well, actually, I have a relationship with this customer and it helps me to work with this particular customer. If I assign these ones to you, can you swap them for me? So the solution isn't always enforce it rigorously. It's always important to consider what is the best outcome for the network and the franchisees. And if there does need to be a variation of the legal obligations, or at least some sort of waiver, that's an important discussion to have with all parties involved. We had another question. Please keep them coming. We're almost out of time, so I think this may be the last question. But again, if we didn't get to your question today, please feel free to submit it, and we'll outline how you can book a time to speak with us. But the last question, looking towards the end of a franchise agreement or relationship, if both franchisee and franchisor want to terminate the relationship mutually, and the franchisee did not wish to sell the franchise business, and the franchisor does not have anyone to take over, what would normally happen here? Would the parties enter into some sort of deed and walk away? It's a very interesting question. This question may be something you want to book a time with us and have a complimentary consultation over. But very briefly, if you're talking about a mutual termination, anything is on the table. If there is a situation where the franchisee doesn't want to sell, they want to operate independently, that's obviously a discussion to have about the restrictive covenants in the franchise agreement, competition restraints and whatnot, as well as obligations regarding confidentiality and intellectual property. And there may be a commercial matter here. We have seen situations where franchisors say to franchisees, you can leave and keep your business, but you have to buy out the rights. And again, this also sets a standard for the rest of the network. But in short, if there is a negotiation for early termination, then all these questions can be factored into what is a reasonable buyout amount, can I get someone else in to service the network, and what impact will it have on the network. We can spend a lot of time talking about this, so I do encourage you to book a time to speak with us. And I think we just had another question, which unfortunately we won't get to today, about controlling franchisee marketing, but Olivia's going to just wrap us up. So thank you very much for your time.
Thank you very much, everyone. That's all we have time for today. After the webinar ends, a survey will pop up. We would really, really appreciate it if you could complete the 30-second survey, and please include your contact details to receive a complimentary legal consultation to discuss how we can help you with effective strategies for managing non-compliant franchisees. Thank you so much for joining us.
Thank you very much.